Yeah, guys, we have Mark here from Netla. He's very expert. He has been doing this for decades on the Wayline Trust, and try to keep your questions for the end. Or if you have any question, you can raise your virtual hand, or you can type in the chat box, and we'll open the Q&A forum at the end. Okay, thanks. Thanks, Mark, for giving time on this evening, on a weekday evening.
No, of
Please
course.
go ahead. Yeah.
Yeah, thank you, Ragu. I appreciate it. Thanks everybody for joining tonight to talk about the very important topic of estate planning. So tonight we're going to talk about several things. We're going to talk about what is estate planning, what are all the documents, and why do we need each one of these documents? And then we're going to talk about, well, what happens if something happens to me and I don't have these documents? What are the ramifications to our family? So we're going to talk about all of that, and then we'll talk a little bit about what net law is and how we help families create their estate planning documents every day. But let me go ahead and share my screen so you can follow along with the presentation. But I think when we talk about estate planning, I think this really, says it all without saying anything. Why do we do estate planning? Right here, right? For the kids, for the spouse. If something happens to us, we want to make sure that everything that we have now or anything that we have in the future gets distributed in the most cost-effective and time-efficient way possible. And that's why we create our estate planning documents. We want to make sure that everything gets distributed according to your wishes. And one of the big things that happens when we create our estate plan is that we stay in control of everything, even after we pass away. We're going to dictate a lot of things. Those things we'll talk about here in a little bit. But the first thing that I want to talk about is for those that don't know what Net Law is, Net Law is an IT company. We are a document creation company that was created out of an estate planning law firm in Louisville, Kentucky called the Hargrove Firm. And the reason that our law firm created Net Law was because back in 2012, we read in a Bloomberg report that said that over 60% of Americans didn't have their will, just that one document. And of course, that was concerning to us because, over 60% of Americans have a, oh, did I lose my screen? Yeah, for some reason, you're the host now again.
Okay, sorry about that, Mark. I think let me make you as host again once.
Okay.
Yeah, good now. Yes.
Okay, good. Here, let me. So the reason that our law firm created Net Law was, again, 60% of Americans didn't have the will. That was very concerning to us because, well, we're in estate planning, right? And 6 out of 10 people aren't coming in to see us to get their estate planning documents done. So we did a little research to find out, well, why is it that people procrastinate, especially when you know how important these documents are? And there were 2 major reasons when we did our research to find out why people procrastinate. One, I think we can all guess what it is. Cost, right? It's very expensive to come in, speak to one of our attorneys, and get your estate planning documents created. But the second reason, nobody wanted to go see an attorney anymore. Think about it. We live in a technology age. There's not hardly anything that we can't do now that we can do on our laptops or on our phones, right? So we said, okay, well, how do we solve both of these issues? And the easy answer was software, right? And that's what we did. We went out and we created NetLaw, which is a software where you can use to create your estate planning documents. How did we do that? We went out and we hired attorneys in all 50 states. And the reason that we did that is because each state has their own rules and regulations that have to be followed according to the American Bar Association. So we went out and we hired attorneys in all 50 states to come in. And what we did is we tasked each attorney, hey, for our software, we need the exact documents that you would give someone in your state. But we want them to be able to receive that in our software as well. So no matter where you live at now, or wherever you move to in the future, you can use the NetLaw software to create your estate planning documents for that state. Very, very important. One of 2 things that separates us from everyone else in this genre. The first one is the big one. We won the James Keene Award from the American Bar Association. Now, the reason that I bring this up is because we are the only ones in estate planning to win this award from the American Bar Association. And this is the award that goes out to the best online delivery of legal documents company. I'm going to say that again. The best online delivery of legal documents. The American Bar Association awarded the Hargrove firm this award. That is our parent company for the creation of NetLaw. And these are all the documents that you get in our full comprehensive plan. Now, as you can read, one plan covers both spouses. And as you read down the list here, you've probably heard of these documents, but maybe don't have a real good understanding of why each one is so important. So we're going to run through these documents, and we're going to talk about the importance of each one. Let's start with the will first. The last will and testament. And there's really three reasons why we do our will. One, we're going to name executors. This is the person or the people that you're going to name that are really going to be in control of almost everything. The role of the executor is to make sure that all of your assets get distributed to your beneficiaries. They're going to make sure that all your creditors are paid. They're going to make sure that your taxes are filed. They're going to make sure that everything is taken care of. Not only do you name a main executor, but you get to name alternate executors as well. And yes, this can be someone from a different state or a different country as long as they're over the age of 18. But you do need to at least name one person from the state of your residence. Very, very important. So that's the executor. Number two, why we do our will, guardians. So if you're a parent of an underage child or children, and something happens to you and your spouse, car wreck, plane wreck. We saw it with COVID. You know, mom and dad both passed away before the kids turned age 18. Who's going to have custody of the kids? Who's going to take care of the kids? So not only, just like with the executors, we get to name main guardians and alternate guardians as well, as long as they're over the age of 18. And at least you have to name one person from the state of your residence. And the last reason that we do our will is we call it specific bequest, but what that is simply listing all of our assets and who those beneficiaries are. Now, why is that so important? Because it stops all the family from fighting, right? How many times have we heard where mom or dad passed away and the kids start fighting over everything? Well, that stops when you have your will in place, because you're going to list all of your assets and who those beneficiaries are. So that's why we do our will. Our executors, our guardians, and listing those assets and who those beneficiaries are. Second line item there is the children's trust. This is included in the will and the trust. And your children's trust it goes back to those parents that have underage children. This is where you get to, you know, if mom and dad pass away and there's underage children, when your child turns age 18, they're going to receive everything. So, but let's remember they're age 18, right? So what the Children's Trust does, it allows you to string out that inheritance so they don't receive the full package at age 18. You can string that out a certain percentage at a certain age, all the way out to age 35. Parents love that option. Third line item is our financial power of attorney. I think we all know what that is, right? Our POA. Naming someone who can make our financial decisions for us if we can't make them for ourselves. Now, one thing to remember, this is a living document. Your power of attorney can only help you for as long as you're alive. Once you pass away, they have no authorization of your accounts. But while you're alive, if you're sick, you're in the hospital, maybe you're overseas, something happens over here, hey, you don't have to rush back. Just let your power of attorney handle everything. Very, very important document. In the beginning, I said this is a full comprehensive plan. Not only are we taking care of your finances, but we're taking care of your healthcare decisions as well. Your healthcare surrogate is your medical POA. Who's going to speak to the doctors and nurses on your behalf? Your HIPAA authorization allows your healthcare surrogate or anybody that you know to see your medical charts or any kind of mental health information like psychotherapy notes. And then your advance directives. In some states, it's called a living will, but this is your end of life decisions. What do you want to happen at end of life? Do you want to be hooked up to a machine and kept alive? Or no, hey, just keep me out of pain and let me pass naturally. right? Your decision. Again, why do we do this? To keep you in control all the way up to the day that you pass away. We even have a pet trust. So if you're a pet lover, great. You can leave money behind for the well-being of your animals. And then the last document, our revocable living trust. You know, most people, when they talk about estate plan, they always say will and trust, right? But let's remember that your will and your trust are two separate documents. They do two totally different things. So we've already talked about the will. But the reason that we want to create our revocable living trust is because this trust is probate avoidance. So let's talk about probate and why you want to avoid it for your beneficiaries. So probate is the process where when you pass away, if you do not have a trust created and haven't transferred assets out of your name and into the name of the trust, all of your assets are frozen. Even if you have a will, the government comes in and freezes all of your assets for a certain period of time, usually around 6 months to a year. And the reason they do that is so that that gives time for creditors to come in and file a claim on your estate. While the probate process is active, none of your assets get distributed to your beneficiaries. But we have a solution for that. If you create your revocable living trust, you transfer your major assets that do not have a named beneficiary attached to it, like your house, car, vacation homes, rental properties, businesses. You can take those major assets out of your individual name and transfer it into the ownership of the trust. Now, again, anything that's owned by the trust avoids probate and is passed to our beneficiaries right away. They don't have to wait that time period. They get these assets right away. Now, remember, I said with probate, I said we want to take our assets that do not have named beneficiaries, right? So what about all of those assets like life insurance, 401k, stocks? Anything that has a named beneficiary attached to it avoids probate automatically. So we're not worried about those. We want to list those in the will, but we don't have to worry about switching those over into the trust because your beneficiaries are going to get those automatically. Again, we create this trust so that we can take care of the assets, the major assets that do not have a named beneficiary. Again, your business, your house, your investment properties, right? So anything like that. And we have a funding instruction sheet that walks you through how to transfer this into the trust. I know it sounds daunting, but believe me, it's not. It's pretty easy, and we can always help you out. And we always have a 7-day money back guarantee. So if you try it out for any reason, you don't like it, we'll give you your money back, no questions asked, as long as you haven't downloaded your documents. This full package, again, covers both spouses. In our law office, this starts at $3,500. But the price for the net law, $600. And stay tuned at the end, because we're going to give you a discount even on that. But our net law cost is $600 for both spouses to create these documents. And I said, there's two things that separated net law from everyone else in this genre. The first thing was the American Bar Association award. Here's the second. This is a software. So not only do you have the ability to go in and create your documents, but you have the ability to go back in and edit your documents anytime that you need to. The kicker is, as all of these life events are popping up on your screen, these are all reasons why we need to edit our documents. It's free of charge to log back into your account at any time. We do not charge a monthly fee, a yearly fee to keep your account open. Most companies do that for $10 to $30 a month. Once you pay the fee to get started, you have full lifetime access to your account. Again, $600 gets you the ability to create your documents, edit your documents. You have full lifetime access to your account. Remember though, just when you create your documents or you edit them, you have to print them out and get them witnessed and notarized. That's what makes them a legal document. But see how we've taken everything of why people work why people
fair
weren't
enough.
doing this. And now we've made it easy. You don't have to go to the attorney's office and you're not going to pay a lot of money.
Recorded message.
So the last 4 slides that I'm going to show you, we're going to talk about everything that we've already talked about, but I'm going to talk about it from the perspective of if something happens to you and you don't have these documents, again, what are the ramifications to our family? So why is it important? Because most people don't realize that if you don't create a will, the state already has one for you. Whatever state that you live in has a will already in place for you. Now, you may not like what it says, but they have one for you. And what that's called is intestate. I promise that's the only legal term I'll use tonight. But intestate simply means that you passed away without a will. The government comes in and says, we don't know how he or she wanted to distribute their assets, so we're going to do it for the family. Now, in Kentucky, where I'm from, our intestate rules, and this is for individually owned assets, or when the second spouse passes away. If I died without a will, all of my assets that I owned individually, 50% of it would go to my spouse, 50% automatically to my kids. That's usually not how people want that to happen, right? Everything goes to the spouse, then to the kids. That's how it normally works. This is where families start fighting because they get a little taste of what they're going to get. And
Family start fighting.
so
Huh?
having our will and making sure that we list
Just
all of our
fighting,
assets
fighting.
and who those beneficiaries are is very, very important. And this is always the first
Fighting.
slide that I show my
Banana
clients.
And Mark, can you mute?
Idea of you
Guys,
started
can you mute yourself? Who is not
When I
Mark.
fight,
Mark, can you mute?
what I say. To whom?
So this is always, so this is always the first thing that I talk about when my clients come in and talk to me. But this is the first slide that I show them if I know they have underage children. So job number 1 of a parent, protect our kids at all costs. Again, if you do not create a will and you have underage children and something happens to mom and dad, hardly anyone knows that a judge will come in and decide who gets custody of your kids. Now, there's 25 of us on this call. I can almost guarantee all 25 of us would say, we do not want a judge making that decision, right? We know who's best to raise our kids. We know who we want to raise our kids. We know who has our the best interests of our kids at hand. But not creating that will and something happens to mom and dad, again, we're leaving it up to the government. Making sure that for our beneficiaries, we avoid probate court for them. And that's actually creating that trust and transferring our major assets into that trust. Because if they go through probate, again, it's very time consuming. You have to wait a long time before you get the assets. And it's expensive. A lot of times you have to hire an attorney, you have to go to court. It's just not worth it. Simply create the trust and transfer those assets into the trust so that when you pass, those assets don't get tied up in the court system. They get distributed to your beneficiaries right away. Last screen, and then I'll answer any questions that you have. Don't skip out on the medical documents. These are just as important as your financial documents. Making sure that we have someone who can speak to the doctors and the nurses on your behalf. It could be an issue of you want something to happen, you don't want something to happen. It could be a religious belief. Hey, this needs to happen. This can't happen at all. But the doctors and the nurses, they won't know that unless something is written down or someone's there to tell them. So having these documents in place, not only your financial documents, but your medical documents as well, is going to be a lifesaver for the family. So this was kind of a net law and estate plan 101 course, right? I hope you learned something. That's always my goal, is that everyone at least learns one thing that they didn't know before this webinar started. And remember, we have a discount because you're here on this webinar. Raghu is going to give a 50% discount to everyone who is on this webinar. So that takes the cost from $600 for all of this down to $300. You just reach out to him. He'll provide all of his contact information here. Raghu, I don't know if there's a time period that they need to reach out to you. I'm sure there is, but I'll let you take over from here and we can start the Q&A session if you want. Oh, you're on mute.
Sorry, I was talking on mute. There are a few questions in the chat box. Can you look at those, Mark?
Yeah, let me pull those up. Can we list someone as beneficiary on will who doesn't have SSN and live outside? Absolutely. Anyone can be a beneficiary of any asset that you have. Doesn't matter how old they are, where they live at, doesn't matter. Anyone can be a beneficiary. Second question, is this applicable only to the assets within the US? No, so you can add your international properties into your will. You can list everything that you own in your will. And we encourage you to do that because, you know, when it comes to the distribution part, we don't want those overseas assets to be missed, right? Now, as far as putting international assets into the trust, that's a little bit more complicated because all deed transfers or title transfers has to happen in the country of origin of the asset. And you still have to follow the law of the land over there. So usually what people do is create a will and trust for their US assets and then one for their international property as well. Hope that made sense. What are the tax implications of passing on the wealth to my beneficiary with or without a will or trust? Yeah, so with inheritance tax, if your assets are under, and this is a couple, a US couple, 26.5 million, if your assets are under that, there is no inheritance tax. Now, there will be tax, like if you owe property tax, if you're receiving that, any kind of bump up in cash value, you will probably have to pay a tax on that as well. What I tell people is get with your CPA or whoever does your taxes. Get with them. Even Raghu can probably help you with saving on taxes as well. So get with him and he can help you go down that by, you know, instead of like taking stock out of mom and dad's account, hey, roll those over. Roll over the 401k so you don't have to. He can help you with all of that. And does it matter if I live in Washington, but I have property out of state? No, absolutely. So you'll create your will and trust in the state of your primary residence. But if you own property in another state, you can just add that right in there and you can do the deed transfer into the state of residence. Great. Awesome. He's put in the 50% discount. There is his website. So click on that. It's in the chat, guys. So make sure you click on that so you can have a good conversation with Raghu. Any other questions? This is the perfect time to ask. So anything that you've ever thought about, go ahead and ask. I have MetLife legal benefits. Do you accept it? No. We don't do employee benefits, but a lot of times, if you go to your HR department and tell them that you want to buy this, if you provide a receipt to them, sometimes they reimburse you. So I would do that. It's happened a lot. I've given out a lot of receipts in the past. So ask your HR department if they will do that.
Thanks.
Mark,
Yes,
hello.
sir.
So does it applies to the any type of securities as well, like cryptos and stuff and ETFs, like
Yeah, I've got my crypto account in my will. And you could just, you know, for that kind of stuff, it's going to go in specific bequest where we list all of our assets. And yeah, I just named my kids as beneficiary of that of my crypto account.
okay, and this whole will and trust will also include the healthcare power of attorney and general GCPOA as well, DP, deep durable power of attorney,
Uh-huh.
and
All of these documents right here. You get all of these documents.
something came up. Okay, yeah.
Okay.
Yeah.
One more
Where is
question.
this
Thank you.
picture?
We have got the subscription. How hard is it to get this completed? What support do we get? Yeah, so once you have the plan in place, great. If you need help, in the upper right-hand corner of your account is a chat bar. Click that, you can chat with us, and we can turn that chat into a video call. And if you need help, we can help you create that. Or you could always get with Raghu. He can help you. And we'll make sure that you get all of this separate started and completed. I think that, getting started is great, but completing it is why we do this. We want to make sure that you're fully taken care of.
Question.
Is you and Raghu have from your family trust and moved assets to trust? I don't know what that question is. Can you see it? Yeah.
In the meanwhile, can I ask?
I'll answer the second part of it though. It's pretty easy. So to transfer your property into the trust, all you do is you take the deed of your property. You have a deed to your property, and you take our certificate of trust document. And what I always suggest is going to a title company in your area. Just make an appointment with them, and they can take your deed, rip it up. They will create you a new deed, but that deed now will not be in your individual names. It will be in the name of your trust. That's what funding the trust is, putting that asset into that trust. I did mine about 3 years ago when I bought this house. It literally took me 15 minutes to do it. It was very easy. And it cost me probably, I think it was like $79, $89. It was pretty cheap. I also heard of notarization these documents. How does this work? Yeah. So you need to print out your documents, get them witnessed and notarized. What I would suggest is if you don't know a notary, go to your bank. They will witness and notarize your documents for you. Yeah, you go to a FedEx office, they'll do it. But I would go to the bank because they usually do it for free. Free is always good.
Mark, this is Punja. Whether you use a Netla software to do your trust and will, or you have your own attorney.
Are you talking for me personally?
Anybody.
Yeah.
Either whoever formed the
Yeah.
trust and will, whether they used a Netla software or they have their own attorney.
Yeah, so all of my family has used this software because you're getting both. This software was created by attorneys, so you're getting an attorney created software for your estate planning documents. You're just filling it, and the way that I explain it, I don't know who asked that question, but it's a good question. Here's how I explain it to people who I talk to about this. Here's the difference between using our software and going into an attorney's office, besides the cost. Let's throw the cost out because we know it's more expensive that way. But here's the cost. If you go see an attorney,